Thank you. So I'm looking forward to debating this question and defending the Human Rights Act and ECHR as key components of our democracy. But it's really important that we engage in this debate in a careful and informed way, not propelled by misinformation and misleading stories. So let's recall a couple of basics about the Human Rights Act and ECHR taken together. Parliament remains sovereign. It has the final say over our rights in domestic law. Courts can't strike down statutes if they find breaches of ECHR rights. They can only issue declarations of incompatibility, which Parliament and the government are not legally obliged to follow. Yes, the UK is obliged in international law to follow rulings against it by the European Court, but as I will show, these are extremely rare. So, to immigration and asylum, why the hostility has been greatest. First, let's be clear what the actual issue is. Michael Ellis, former Conservative Attorney General, has claimed that it is simply a fact that remaining in the ECHR means our government will be unable to deliver meaningful reform of our immigration and asylum system. That is misleading. Because the ECHR says nothing whatever about immigration in general. States are entirely free to set their own policies of how many visas they give, for what purposes, tourism, work, etc. The UK could drastically reduce immigration tomorrow and the ECHR would say nothing about it. The ECHR only applies to the issue of returning those with no right to stay here, often failed asylum seekers, to their own or third countries. And it does so in two ways. First, it prevents return mothers at real risk of death or inhuman treatment or torture under Article 3, and second, it prevents deportation, where doing so would have a seriously destructive effect on their family in the UK under Article 8. So as to the first, it's important to note that this is not an invention of the Strasbourg Court, as is sometimes said. The UK signed the UN Convention Against Torture, UNCAT, in 1985 under the Thatcher government. Article 3 of UNCAT, in terms, prohibits states from extraditing people to states from people where there is a substantial risk of them being tortured. As to Article 8 in family life, it's in this area where I think the most misleading impressions have spread. So some basic facts. In the last 45 years, 29 cases were brought to the European Court against the UK re-deportation. The government won 16 of them. Of the 13 cases the UK lost, just 4 concerned family life. So on average, it's been calculated judgments of the European Court of Human Rights prevented removal of a foreign national once every 4.5 years. The latest example in 2020 was the court ruling a Nigerian man convicted of falsifying immigration documents could not be deported because of the impact on his 3 young and financially dependent children, all of whom were British citizens and one of them needed heart surgery. Okay, fine, you might say, what about the Human Rights Act? Well, here too, successful human rights-based appeals against deportations are rare. The latest Home Office figures show that over a 5-year period to June 2021, 26,000 foreign offenders were deported. Of these, 645 successfully challenged their deportation on Article 8 grounds. That is 1/40th of the total, 2.5%. Add those who resisted deportation because of the risk of torture or ill treatment on return, and you still only get to 3.5% of the total number of such deportations. And that's partly because Parliament and the government together have made detailed rules that provide a complete code for the judges to apply when they're determining Article 8 claims in deportation cases. So the judges decide cases on the basis of the rules and exceptions formulated by Parliament. And the key rule is that the Home Office must issue deportation orders against any foreign national sentenced to imprisonment of 12 months or more. There are only narrow exceptions, and they only apply in cases of serious damage to family life or risk of torture or treatment. So how has the perception gone about that deportations are constantly being frustrated by what Kemi Badenoch has called comically ludicrous interpretations of the ECHR? As a recent Bonavera report shows, there are 3 kinds of errors in reporting which have led to this. First of all, decisions of first-tier tribunals in favour of deportees are often reported as final, despite having been already overturned on appeal. Second, claims or arguments made by lawyers for a deportee are sometimes reported as if they were the judgment of the court. And third, a fact mentioned in the judgment is sometimes reported as the reason for the decision. So some quick examples before I finish. 2 of those errors were the basis for a very widely reported but wholly false story that an Albanian man could not be deported because his son loved chicken nuggets so much. In fact, the initial decision to block his deportation was overturned on appeal, and in any event it never rested on anything to do with chicken nuggets. It was something simply mentioned in the first-tier tribunal. But by the time the story had started being reported, the original decision blocking deportation had already been overturned on appeal. But boy, that story had legs. Both Kemi Badenoch and Nigel Farage relied on it to attack the ECHR. Similarly, it was widely reported that a paedophile couldn't be deported to Pakistan because he would be persecuted as an alcoholic, about which Kelvin Mackenzie said he couldn't make it up, but he was deported because the decision was overturned on appeal, something not reported. Or finally, a few years back, Theresa May as Home Secretary telling the Conservative Party conference that a tribunal had recently found an illegal immigrant cannot be deported because, and I am not making this up, he had a cat. In fact, his having a water cat with his partner was something mentioned in the judgment as part of a long description of the life he built with his partner, but was not the basis of the decision. So in a very real sense, she was making it up. So to conclude, by all means, let's debate Article 8 and indeed the ECHR, but please let's have the debate on the basis of an accurate understanding of how the Convention actually works, and in particular the very, very small contribution it makes to the problem of deporting those who have no legal right to stay in this country. Thank you.